Just for housekeeping, before I do my opening statement, we are going to have votes beginning at, I believe, somewhere between now and 2:45. I've instructed the cloakroom, unless my vote is needed to break a tie, that I don't intend to recess the hearing, so we'll charge through. But if I have to leave, it is, in fact, because I need to break a tie. Don't anticipate that. And I know that you all put a lot of work into this preparation, and I want to show you the utmost respect of not having your testimony in these discussions to be interrupted. Today we discuss a topic that I think in my time here has been often confused and mischaracterized, and I actually believe it's one of the most important issues facing our country today in the patent community. It's the topic of patent eligibility reform. The long overdue need for patent eligibility reform is one that if left unaddressed, will cede America's well-earned title of the global innovation leader and global intellectual property rights leader to other communities. Can't let that happen. And under my watch, which incidentally is over the next 452 days, it will be one of my top priorities in my office. The sad part about the potential loss of our, what I believe, championship status in the IP and intellectual property protection community is foreign governments like the CCP are actively working to undermine our IP system. And they're attempting to overtake America's position as the global IP leader. As I said before, there are those in this country who rather than fix the problem, would like to take advantage of ambiguity or, the comfort with the status quo that's been created because of the confusing and I think sometimes conflicting outcomes in our courts. Now, we have 4 relatively recent Supreme Court decisions that have caused patent eligibility law in the U.S. to be confused, constricted, and unclear. That's what we're trying to fix here, folks. It's led to inconsistent lower court decisions, uncertainty in innovation, uncertainty in investment communities, and unpredictable business outcomes, all things that, if you know me, I don't like. Research has confirmed that under the expanded judicial exceptions, U.S. inventors are unable to obtain patents in areas where economic peers offer protections. This is particularly concerning in the economically critical areas of biotechnology and computer-implemented invention, where patent restrictions decrease investment and send capital overseas. As of 2021, all 12 then-sitting judges of the U.S. Court of Appeals of the Federal Circuit Court lamented the state of the current law. I've always said that we should not rush to legislate and that we should let courts do their job until they don't. And that's where we are now. Case in point, in 2021, I worked with former U.S. PTO Director David Capos, who we'll hear from today, and retired Judge Paul Michel to file an amicus brief in the American Axle case. I was disappointed to see the Supreme Court decline the opportunity to offer clarity on patent eligibility, so we still have a lot of work ahead of us. And while former USPTO Director Andre Iancu, who's also we'll hear from today, made great strides with the 2019 PEG, the Revised Patent Eligibility Eligibility Guidance. It changed how patent examiners review patents, but the guidance is not binding on the courts, and when patents are challenged in litigation, the guidance lacks the force and effect of law. That's why I've introduced the Patent Eligibility Restoration Act of 2025, or PARA, along with Senator Coons. Earlier this year, I was happy to see Senators Blackburn and Senators Hirono join as co-sponsors. PARA preserves the first part of the current eligibility statute, but it eliminates an overly broad set of 3 current judicial exceptions, replacing them with 5 specific, defined statutory exclusions. By eliminating and replacing the current judicial exceptions, PARA provides predictable patent eligibility for important computer-implemented technology developments and medical advances, creating a solid background for America's innovation future. It's important to note that patent eligibility and patentability are often conflated. This is a tool that opponents to patent eligibility reform, I think, often leverage to sow confusion and paint the narrative that expanding patent eligibility will equate to rampant and uncontrolled patentability. I disagree. Section 101 was not intended to function as a gatekeeper to keep out ineligible patent claims. Patent eligibility is simply one step in the process of determining patentability. Should a patent examiner find a claimed invention fails to meet one or more of the requirements outlined under sections 101, 102, 103, and 112, a patent will not be issued. Simply meeting the requirements of section 101 does not mean that a patent will be granted. I will remain a champion for strong, reliable, and predictable intellectual property rights and for inventors and creators, large and small. And as part of that promise, I will not stop shining spotlight on the need for patent eligibility reform. I'm also heartened to see that our current USPTO Director, John Squires, shares this understanding and that we need patent eligibility reform and that the status quo is not sufficient. This is no more evidence than by his ceremonial signing of 2 patents last month on technology generally considered not to be eligible under Section 101. I hope that this is our last IP subcommittee hearing on this topic and that we will soon move to PARA and a markup in this Congress. I will be entering my I've already stated all my opening comments.